Hello students, and welcome to our class today. My name is Augustus Mutemi, as you can see from your screen. I'm going to take you through the lecture of hire purchase in commercial law. This is an extension of the discussions and lectures that we've been having on Microsoft Teams and also on the e-learning portal. Remember, the university has been innovative enough to come up with two digital platforms that we've been utilizing in proceeding with our lectures, so that our lectures are not going to stop just because we are not having face-to-face interactions. And therefore, last week we met on Microsoft Teams. We had our class on discussions on carriage of goods. And therefore, today we continue with that discussion, but on a different topic. I'm going to take you through hire purchase. But before we proceed, I would want us to have a recap of what we discussed last week. You remember that I took you through our discussions on the legal frameworks governing carriage of goods. Remember, by its very nature, carriage of goods, the law of commerce will involve carriage of goods, because once the seller and the buyer enter into the contract of sale and the contract is concluded and the buyer has an opportunity to pay for the goods, then those goods have to be transported from the seller's premises to the buyer's premises. And that is why, as the students of commercial law, we have to understand the legal frameworks that govern carriage of goods. We said that carriage of goods has an extraterritorial nature, is in the nature of buyers and sellers crossing boundaries, because we could be having a buyer who is located in Nairobi and a seller who is located in Tokyo, Japan, and those goods, after the contract has been concluded, have to be transported to Nairobi. The mode of transport will depend on the bulky nature of the goods, the perishability of the goods. If the goods are perishable, then you'll agree with me that the buyer and the seller will agree on a mode of transport that takes a short duration of time. And therefore, we discussed carriage of goods by sea. We discussed the many conventions, the international conventions that govern carriage of goods by sea. We went through the Hague rules, the Hague-Visby rules, the Hamburg rules, and then the Rotterdam rules. It was an extensive discussion that we need not go back to. You referred to your video lecture that I recorded, and you're going to see what you might have missed. Then we went to a discussion on carriage of goods by air. We went through the various international conventions that govern carriage of goods by air. And we touched on the Warsaw Convention, the Warsaw system of conventions, and then you cannot forget the Hague Protocol of 1955. We discussed the Guadalajara Convention of 1964. We also discussed the Montreal Additional Protocols of 1975. You should also not forget the most recent convention, which is the Montreal Convention that we discussed, and also the Carriage of Goods by Air Act of Kenya, because it is that act which domesticates these international conventions. We also discussed the carriage of goods by road, and we agreed that this is the most popular mode of transport within the East African community, because you have those trucks crossing the Kenya-Tanzania border, you have those trucks crossing the Kenya-Ugandan border, and we have trucks going as far as to the DR Congo, and therefore carriage of goods by road is the most popular mode of transport. And we discussed the convention, the international convention that governs carriage of goods by road, but we said that Kenya is not a party to that convention because we did not see the need for Kenya becoming part of an international convention, yet we do not have a road network that connects Africa and the other continents. And therefore, Kenya might have decided that there's no need of being party to such kind of conventions. And therefore, the Traffic Act and the other laws of the Republic of Kenya govern road transport in Kenya. We then discussed carriage of goods by rail, and we said that rail network is being modernized. You note that we have the SGR. We are trying to modernize rail transport, and there is an agreement between the East African partner states that they are going to connect the countries making part of the East African community, so that goods could be transported safely from one country to another to promote trade. It's a long discussion that we cannot go back to, and we will keep reminding ourselves about these conventions because it is an extensive legal framework that we discussed last week. For today, we want to go through the following outcomes, and these are the objectives that we want to achieve, so that by the end of the class, I expect you to be able to, number one, to distinguish between the hire purchase contract and the contract of sale. By the end of the class, you should be able to distinguish between the hire purchase contract and the contract of sale. Remember, we have already covered the contract of sale. We have already covered the nature of that contract of sale, and we have even drafted contracts which formed part of your Cat 1. And number two, I would expect you to be able to explain the concept of passing of property in the hire purchase contract. How does property pass, and when does property pass? And by passing of property, what we mean is that at what point does ownership of the goods pass from the premises of the seller to the premises of the buyer? At what point do the goods become the property of the buyer? And lastly, I would expect you to be able to analyze the Hire Purchase Act with a view to explaining the obligation of parties and remedies in the event of breach of those obligations in the hire purchase contract. Because the hire purchase agreement is an agreement like any other, and you expect that once the owner of the goods, who is the seller, and the hirer, who will later on become the buyer after they have paid the very last installment, that is a discussion that we're going to have, they enter into a contract, they enter into an agreement. It is drafted like any other agreement. We drafted the contract of sale, and we will have an opportunity to also draft the hire purchase agreement, so that you appreciate the nature of this agreement. So these are the objectives, so that by the end of the class, if you will not have been able to achieve these objectives, then you note that you have not understood our topic today. We start by defining hire purchase agreements. What are they? But before we define hire purchase agreements, we want to take a brief history because hire purchase agreements in Kenya and the law governing hire purchase agreements has got some history. It did not just start by being there. It has got some history. And the history can be traced back to the era of capitalism. We have had extensive discussions about what capitalism is. And we said that during the age of capitalism, we had buyers and owners of goods whose objective was to amass as much wealth as possible, even if at the expense of their buyers. And you could have sellers hiking their prices, hiking the prices of their goods, not selling goods that are of merchantable quality, sometimes selling goods that do not belong to them. And then it was a weird situation because where sellers could sell their goods in hire purchase terms, they could hand blank documents to their hirers, so that the hirers are going to fill in details in that blank document, and the seller could then fill in favorable terms, in the absence of the hirer, so that the hirer will have to pay high prices for the same goods because when they are entering that contract, they did not notice the price of those goods. And therefore, it was a very weird situation because we had unscrupulous sellers and unscrupulous owners of goods who are selling their goods at high prices. The goods may be of low quality, may not be of merchantable quality, may not fit the purpose for which they are being sold. And on the other hand, we have buyers, we have hirers who may not pay the very last installment. And therefore, after paying one or two installments, they could decide, now we do not need these goods. I no longer need these goods. I need some new goods. I need a newer version of this car. I need a newer version of this electronic gadget. And it was such a weird situation. We had unscrupulous sellers. On the other hand, we had buyers who were not ready to pay. And therefore, there was the need to have this industry being regulated. And that is when we have the English commercial laws coming into being. Remember the history that we went through when we were trying to trace the history and development of commercial law. We said that we have borrowed most of our laws from the UK, and therefore even the Hire Purchase Act that we have, Cap 507 laws of Kenya, is a replica of the UK Hire Purchase Act of that time of 1893. And that is how far we have come, so that the hire purchase laws that we have in the country are meant to regulate the industry, the commercial environment with regard to sale of goods by hire purchase terms. And we have so many dealers selling their goods in hire purchase terms, and there are many reasons for that. The hire purchase price is almost always higher than the cash price, and therefore such sellers, such owners of goods may try to risk and sell these goods under hire purchase terms, whose price is almost always higher than the cash price, so that they get some profit over and above what they would have gotten if they had sold the same goods on cash terms. And we also have the buyer, the hirer on the other side, who does not have ready cash. You only have a few coins, and if the seller is able to agree, if the seller can agree that I will be paying some installment every month, I should be able to complete this this payment within 10 or 12 months or so. And therefore, there are so many reasons why there are hire purchase agreements being entered by sellers out there, by sellers and buyers out there. So the law that we have in Kenya is the Hire Purchase Act, Cap 507 laws of Kenya. You need to download this act and you read for yourselves. Having gone through that brief history, we want to see how the act defines hire purchase agreement. And I have copy-pasted for you. It can appear lengthy, but for law, we just have to say it as it is. If you want to understand the hire purchase agreement, it is defined under Section 2 of the Hire Purchase Act. This is how Section 2 defines the hire purchase agreement. Hire purchase agreement means an agreement for the bailment of goods under which the bailee may buy the goods, or under which the property in the goods will or may pass to the bailee, and where by virtue of two or more agreements, none of which by itself constitutes a hire purchase agreement, there is a bailment of goods, and either the bailee may buy the goods or the property therein will pass or may pass to the bailee. The agreement shall be treated for the purposes of this act as a single agreement made at the time when the last of those agreements was made. This is a long definition, and it is characteristic of many other and all definitions that our laws provide under the Section 2. But being law students, being scholars of the law, we should be able to isolate the keywords, the words that are going to guide us in understanding what hire purchase agreement is. And this is what we isolate. And we can trace the keywords from the case of Hellbe versus Matthews, a very old law, but the law developed in that case still stands supreme, because you look at the cases that have been determined under this subject, hire purchase agreements by our courts, and you can get that from the electronic version of the Kenya Law Reports, the electronic database of the Kenya Law Reports. You just type hire purchase and you'll find a plethora, many cases dealing with hire purchase agreements. They have quoted the law developed in Hellbe versus Matthews in 1895. Now, this case involved the sale of a piano. The owner of a piano agreed to sell the piano to the hirer. Remember, we call him the hirer because he has not yet become the buyer. He becomes the buyer after paying the very last installment. So he is the hirer as per the law. So the owner of the piano decided and agreed to sell the piano through hire purchase terms to the hirer, and the hirer would pay the price within 36 by 36 installments, so that every month you would pay one installment, and that means you would pay for the piano for let's say 3 years. That's too much for today. I believe that the installments could be much more, so that the payment is done within a shorter duration of time. And the argument was that if the hirer pays the very last installment, he would own that piano. You pay all the installments habitually. Every month you pay £1, and then you are going to own that piano after paying the very last installment. So property in the goods was to pass after the payment of the very last installment. That was the argument. And what did the hirer do? He paid a few installments, and after paying those few installments, he decided to use that piano as security for a loan. He approached a pawnbroker, and they agreed that he obtained some loan, and he would use that piano as security. In other words, he would deliver that piano to the possession, to the premises, to the custody of the lender of the loan or the pawnbroker, and that piano would serve as security for that loan. Remember, the piano has not yet become his property, and he decides to use it as security for a loan. You can only use what you own as security for a loan. You can only use your own car, the car that you have a logbook to. The logbook is in your name. You can only use that which you own as security for loan. But this guy decided to use that which he did not own. So the case went to court, and the court was to decide whose piano was this. And it had to trace the facts of the case, that the owner of this piano decided to hire it. He decided to sell it to the hirer on hire purchase terms. The hire purchase price was to be paid within 36 months. 36 installments were agreed upon. But before the payment of the very last installment, the hirer decided to use this piano as security for loan. He did not pay the very last installment, and therefore the court did not have much problem deciding that property in the piano never passed, at any point, never passed to this hirer. And therefore, the real owner of the goods, the real owner of the piano, had a right to recover that piano. And therefore, there was no way this piano could be used as a security for loan. So what we get from this case is that we have two very, very important elements of the definition. We have the contract of hire. So by its very nature, hire purchase is a contract of hire, is a contract of bailment, so that if you pay the very last installment, the goods are going to become your property. You are going to own those goods. But before you pay that very last installment, you cannot own those goods. And the owner of those goods may recover those goods, may recover their goods. If they decide that you have defaulted in payment for 1 or 2 months or 3 months, they decide that now we cannot allow you to continue making use of these goods. We can recover their goods. And the second element is the option to purchase. So that the agreement itself has an option to purchase, so that if you decide to exercise this option to purchase, you pay the very last installment. You pay the very last bit of the hire purchase price. This is the law. This is what the law is saying. And therefore, you cannot run away from the law. If you do not pay the very last installment, there's no way you're going to own those goods. So from that lengthy definition under Section 2, we get those two very important elements to isolate from that definition. So by its very nature, it is a contract of hire, but with an option to purchase. There is no obligation. If you do not want to pay the very last installment, then no one is going to force you, and the owner of the goods can recover their goods, and the legal process proceeds after that. The Hire Purchase Act does not regulate all agreements, all hire purchase agreements. The scope is very narrow. It only covers a few hire purchase agreements. And the Section 3 of the Act provides that agreements that are covered by the Hire Purchase Act are only those that do not exceed 4 million. Remember, this value can be reviewed from time to time by the minister in charge of trade, and therefore when this act was enacted in 1968 and came into force in 1970, this value was 100,000. It's been hiked to 4 million. So that if your business does not deal with goods, if your business deals with goods whose value is more than 4 million, then the Hire Purchase Act does not cover you. And the understanding is that those undertakings, those enterprises, those traders who sell goods with the value of 4 million and above have got their own legal mechanisms of protecting their property in those goods. They have got their own legal departments which can advise them on the best way to sell their goods. So the Act does not cover those enterprises that deal with goods above 4 million. Of course, that is what I've said. It's meant to protect the economically disadvantaged traders who may not know how to approach the protection of their property when unscrupulous hirers decide not to pay the very last installment. How do we distinguish between the hire purchase contract with other contracts that may appear to be contracts of hire, but they are not? We differentiated all these contracts from the contract of sale in our first 3 weeks when we met, when we were discussing the contract of sale. But today we want to distinguish them from the hire purchase contract. And the first distinction is between hire purchase and credit sale. Credit sale is not synonymous with hire purchase contract. The two terms are not coterminous. So that in hire purchase, we have someone deciding and entering an agreement to sell their product, to sell their goods on, so that the price is going to be paid in installments. The hire purchase price is going to be divided. It's going to be broken down into equal parts, so that if the hire purchase price is 10K, for example, 10,000, and the agreement is that this price is to be paid within 5 months, then we are going to divide 10,000 with 5 months, and we are going to get 2,000. Of course, there is going to be a deposit. The seller may demand that the buyer or the hirer pay a deposit of, let's say, 3,000 or 5,000, and then the remaining money is going to be subdivided between those 5 months that the hirer is willing and ready to pay. We are not interested in those arithmetics. Our interest for commercial law is the law governing those agreements. For credit sale, the buyer agrees to pay the price within a certain duration. The whole price is going to be paid at once, and therefore the buyer enters an agreement with the seller to take the goods with them, but the price is going to be paid much later. Remember, the credit price is the same as the cash price. There's no difference. The only agreement is that the buyer will pay after some time, maybe within a week, 2 weeks, or 1 month, or a similar period of time. And therefore, the only difference between hire purchase and credit sale is when property passes. And the other minor difference is how the price is to be paid. So property in hire purchase agreements does not pass until the payment of the very last installment. In credit sale, property passes, and there are traders who obtain goods on hire purchase terms, and they proceed to sell them to their buyers, and they make use of the money they get from the sale, from the proceeds of the sale, to pay back their sellers. And that is agreed, because in credit sale, property passes just in the same way it would pass in a cash sale. What about in bailment? How do we differentiate hire purchase agreements with bailment? We discussed bailment to say that in bailment, a owner of goods agrees to deliver those goods to a bailee. The owner of the goods is called the bailor. The the second person to whom the goods are going to be taken and who is going to take custody of the goods is known as the bailee. And the agreement is that you will keep these goods for this time. The time is agreed. Sometimes it could be indefinite, but you're going to keep these goods for this duration of time or indefinitely until the purpose for which you took the goods is done, lapses, is accomplished, so that property does not pass. Examples of bailment is when you take your car to a mechanic. You have taken the car to be repaired by the mechanic. You do not transfer ownership of that car. The mechanic is going to repair the goods, the motor vehicle, and you're going to pick your motor vehicle. You're only going to pay the fees for fixing that car. Property in the goods does not pass. But in hire purchase contracts, property in the goods passes upon the payment of the very last installment. We could have differentiated with other contracts like agency, etc., but this discussion is going to continue when we meet on Microsoft Teams. Good. So what are the formalities? What are the standards that have to be met for the hire purchase agreement to be said to be complete? Yeah, what are the formalities? What are the standards that have to be met? Now, these standards are well stated in the law, and that is the Hire Purchase Act, Cap 507 Laws of Kenya. You read Section 5 of the Act, and you're going to find that all hire purchase agreements have to be in writing and registered with the registrar of hire purchase agreements within 30 days after making the agreement and a certificate obtained. And therefore, when you enter hire purchase agreement with your, supposing that you are the seller, supposing you are the owner of the goods, you enter the agreement with your hirer, you have to deposit that agreement, which must be in writing, written in English, has to be deposited with the registrar of hire purchase agreements within 30 days. And remember, this registration involves you paying for stamp duty, etc., so that if you do not register this agreement, it doesn't have the force of law, because in a way you are denying the government of revenue, you have not paid stamp duty, and you have not invited the force of law to govern your agreement. In some case, and that is the case of Tawawa Supermarkets versus Fina Bank, it was held that such an agreement, if not registered, it may not be void straight away. It may be taken to be a contract so that the seller could recover his money from the sale of those goods through hire purchase agreements. But before you get there, courts are not going to allow you to enforce that which is not recognized under the law. And we studied that under the law of contract. So you got to register your agreement within 30 days with the registrar of hire purchase agreements. A hire purchase agreement cannot be registered if it is not in English or where the required stamp duty has not been paid as per the law. Now, Section 4 establishes the registry. This is the registry that you're going to register your hire purchase agreement with. Now, Section 6 now has so many requirements, so many conditions, so many formalities that have to be met by the owner of those goods. Number one, a trader is required by law to inform a hirer in writing of the cash price of the goods. And this is to enable the hirer to make an informed decision so that you know what the cash price is and you know what the hire purchase price is. There's nothing to be hidden, so that if you decide to buy the goods in hire purchase terms, you know the repercussions. You know that you're going to pay a higher price, and therefore it will not be a shock that the owner of the goods is demanding more than what you would have paid had you bought the goods in cash terms. Section 6, subsection 2 of the Act requires that there is a written agreement which must be signed. Of course, it is the hirer who has to sign this agreement, and also the owner of the goods who also has to sign. And by signing, you have executed that agreement. You bind yourselves, you commit yourselves to paying, this price, and you agree that if you do not pay this price, the terms of the contracts, the terms of the agreement are going to apply against you. If one of the terms of the contract is that the owner is going to repossess the goods, is going to repossess those goods. If the other term of the contract is that you're going to be taken to court to pay for the return of the goods and also for any defect in the goods, if the goods are not in the same way they were, are not in the same condition they were when you acquired them from the trader, then you're going to be forced, you're going to be compelled to return them in the condition they were in. Of course, sometimes it is not possible to return the goods in the condition they were in. Suppose the goods in question is a car. The tires are worn out, the engine, mileage is high. There's no way you're going to return it to the other condition. So you have to pay some money. You have to compensate the owner of the goods for such kind of things you've done to his goods. The agreement also contains the amount. The amount is the hire purchase price and also the dates of payment of each installment. All these are the formalities, are what we are calling the formalities, the requirement that the owner of the goods has to inform the hirer of the cash price, has to send a copy of the agreement to the hirer within 21 days. Those are formalities that have to be met. And if they are not met, remember, if there's a dispute that is taken to court, courts of law are going to ask themselves, were the provisions of Section 5 and 6 of the Hire Purchase Act followed? Were they obeyed? And if they are not obeyed, then you cannot take your dispute to court with dirty hands. You have to make sure that your hands are clean when you want to be awarded remedies in a court of law. And that is what the law of equity provides. We proceed. What are the consequences of non-registration? Section 5(4), Section 5, subsection 4 of the Act provides that the agreement cannot be enforced, although courts of law are departing from this statutory provision. Of course, the first port of call would be the statute. What does the statute say before the court start being innovative enough to change this position? The first port of call is going to be, what does the Act provide? And Section 5, subsection 4 provides that this agreement cannot be enforced if you have not registered it with the registrar of hire purchase agreements. You cannot enforce it. You cannot invite courts to decide which is not recognized under the law. Of course, I've mentioned the case of Tawawa Supermarkets versus Fina Bank, where the court held that the agreement is itself not void. It is voidable in the sense that it can be enforced as a contract, but as a hire purchase agreement, it cannot be enforced. It can be enforced under the law of contract. Of course, the other considerations now under the law of contract, all those elements forming part of the contract have to be decided by the court of law. And you will have to look at the case of Fidelity Commercial Bank Limited versus Agri-Tools Limited and 3 others. Very recent case. You get it on the Kenya Law Reports, the digital version. Here the court held that an owner has no right to recover a motor vehicle from the hirer where the hire purchase agreement had not been registered. That is a position of a court of law. What are the implied terms, conditions, and warranties? When we were discussing the contract of sale, we came across several implied terms, which we found them under sections 14 to 17 of the Sale of Goods Act, Cap 31, laws of Kenya. And we said that implied terms are implied by the law and also by courts. Remember, when you are discussing in your law of contract in first year, you are taking through the contents of the contract itself, and you discussed the terms of the contract, and you said that terms could either be express or implied. For express terms, you find them in the agreement itself. They are well laid down in the form of clauses. There's clause 1, clause B, clause 1, 2, 3, 4, depending on the size of the agreement itself. But for implied terms, the law implies those terms into the agreement for the parties. The law implies the terms. The term is not there, is not expressly provided for in the agreement, but the law is there to ensure that there is justice, and only those terms that more likely than not should have been included in the agreement itself, and the court finds that these terms are not in the agreement, the law allows the court to imply. And there are two ways that the court can imply: from the conduct of the parties and from statute. Yeah, of course, the court itself has got its own innovative ways of inferring or implying terms into the contract. And these terms are very similar to the terms that we discussed under sections 14 to 17 of the Sale of Goods Act Cap 31 laws of Kenya. But for hire purchase, you find these implied terms under section 8 of the Act. Of course, one of the provisions is that the hirer is going to enjoy quiet possession of the goods, so that no third party will start looking for the hirer, claiming that these goods belong to me, because the owner of the goods, the seller, committed themselves that they own these goods. So there's no way that a third party should come to claim that they own the goods. The goods are going to be free of any charge or encumbrance, and what we mean is that the goods should not have been attached to any burden. For example, one of the burdens that goods could be attached to is security for a loan. If you are buying a car, the logbook of the car or the car itself should not have been used as security to obtain a loan anywhere, should not have been subject to a charge, not have been subject to a pledge. Yeah, we discussed that. So it has to be free. It has to be a clean property, a clean title. The seller will have a right to sell. That is an implied term. The goods are going to be of merchantable quality. The goods are going to be fit for purpose. The only rider for goods being fit for the purpose for which they are being sold is that the hirer must explain that purpose, so that we are not expecting the owner of the goods to know the purpose if the hirer has not stated that purpose himself. You have to state the purpose so that the seller will assure you that the goods are fit for that purpose for which you are looking. You are looking to purchase those goods. Of course, all these other implied terms are very straightforward, and we need to proceed. Termination of the agreement. This agreement can be terminated just like any other agreement, because it is an agreement at the very outset. It is a contract. Any contract can be terminated. Remember our discussions on the contract of sale. We said that this contract is entered between the buyer and the seller. That is what Section 3.1 of the Sale of Goods Act provides. And there are obligations of the seller, the obligations of the buyer. And once those obligations have been met, have been met by the seller and the buyer. For example, the seller has delivered the goods to the buyer's premises. The buyer has paid for the goods. This contract comes to an end. The parties are discharged of their responsibilities, of the obligations under that contract. And that is why under Section 12 of Cap 507, we have ways in which the agreement of hire purchase can be terminated. Either party is free to terminate that contract. A hirer has a right to terminate the agreement any time before the final installment falls due. And how do you do that? If the hirer has a right to terminate the agreement before paying the final installment, it means that you do not want to own these goods in the end. And you decide that I have had enough of these goods, I want to return them. But now you cannot just return them. You have to meet some conditions. You have to fulfill some requirements. You have to ensure that you meet the cost of returning the goods to the seller's premises. You will not ask the seller to come for the goods. It is you who is now fed up with the goods and you want to return them. You have to meet the cost of returning those goods. And there is another requirement. The hirer is liable to pay all the installments due by the time plus the sum, if any, that is required to make his total payment not less than half of the total hire purchase price, unless a sum is specified in the agreement. This complicated language, and we want to make things easier for you to understand. What this provision means, Section 12, what this provision means is that if you had not paid half of the hire purchase price, let us assume that the hire purchase price of the goods was 100,000, and you had not yet paid 50,000. That is half of the hire purchase price. By the time you're returning the goods, you have to ensure that you pay half. You pay that 50K. That is what the law requires. And this is meant to compensate for any wear and tear, any depreciation in value, because you are returning the goods not in the same condition as they were when you obtained them. And then you have to make sure that you compensate for the condition that you're returning the goods in. And therefore, the law requires that if you had not yet paid half of the hire purchase price, you're required under law to make sure that you pay half before returning the goods. On top of that, you have to meet the cost of returning the goods. Yeah, if it is a car, if it is that electronic equipment that you hired from the seller, you have to make sure that it is you who is going to return it. If you do not do that, of course, there is an agreement that you signed, and the seller of the goods is at liberty to take you to court, and you make good your commitments in the terms of the agreement. Any provision for a larger payment is void. This is referred to as the minimum payment clause. Of course, the agreement itself is going to state how much the hirer will be required to pay. Sometimes it is higher than this half of the hire purchase price, because the sellers want to recover as much as possible from the sale of their goods. They're in business, remember, and they do not want to make losses. Of course, there is going to be a term in the agreement with the effect that the hirer, if they want to return the goods before paying the very last installment, they are going to pay this amount. If such a clause, such a term is not present in the agreement, then Section 12 is going to be resorted to by the court to solve that dispute. Under Section 12, subsection 2, the hirer will be liable in damages if he fails to take reasonable care of the goods. Yeah. If you do not take reasonable care, remember, you are a bailee. You do not own the goods until you pay the very last installment. If you obtain a car on hire purchase terms and you decide that let me drive wherever I want to drive, I go to the countryside, I leave the tarmac, I go to off-road, because after paying 2 or 3 installments, I'm going to return it. No, that is not how things work. You have to take reasonable care of the goods. You have to ensure that you take reasonable care. And what is reasonable for the eyes of the court depends on a case-by-case basis. If it is an electronic equipment, the standard of care is going to be different from when the goods are maybe books or such other kinds of goods. Where he terminates the contract, he must return the goods at his own expense. That is what we've just said. The owner may also terminate the agreement and repossess his goods upon breach of the contract by the hirer. Yeah, this is particularly due to non-payment of the installments. That is default, and this power to terminate is subject to Section 15. And what does Section 15 provide? Where goods have been let under a hire purchase agreement and 2/3 of the hire purchase price have been paid, whether in pursuance of the agreement or of a judgment or otherwise, or has been tendered by or on behalf of the hirer or a guarantor, the owner shall not enforce any right to recover possession of the goods from the hirer otherwise than by suit. So what we mean is that if the hirer had paid 2/3 of the hire purchase price, and let us assume that the hire purchase price is 90,000 and the hirer had paid more than 60,000, that means he has paid more than 2/3 of the hire purchase price. There's no way that upon default, upon failure to pay the remaining installments, the owner of the goods is not allowed to storm into the premises of the buyer, of the hirer, and recover the goods and repossess the goods. You're supposed to file a suit in a court of law. It is the court of law that is going to determine that dispute, and it is going to issue orders. It is going to award you remedies accordingly. So there's no way the owner, after pocketing more than 2/3 of the hire purchase price, they are going to storm into the premises of the hirer and repossess the goods just because the hirer has defaulted in payment of the installments. That is the law. That is what it provides, and the owner cannot go against what the law provides, cannot contravene what the law provides. The last part of termination, the owner may, however, be compensated for his loss by an award of the outstanding balance of the hire purchase agreement. And this is the beauty of going to court. You're going to be compensated, and that means that the remaining installments are going to be paid. The hirer is going to be compelled by the court to pay the remaining installments, and you're also going to be compensated because you entered this business to get profit. And this hirer wanted to deny you this profit. There's no way the court is going to allow them to run away from their obligations under the hire purchase agreement. And you find this under the case of Elijah Barasa Wepukulu versus Munir Omar and two others. It's a High Court decision of 1999. What are the duties, rights, and remedies of parties under the hire purchase agreement? Yeah, we start with the duties of the hirer. The hirer has a duty to take delivery of the goods. If you have entered this contract and the agreement is that you take delivery, taking delivery means that you accept the goods because you have entered a contract and the goods have been delivered by the seller to you, and therefore you have an obligation to take delivery, to accept the goods. The hirer also has a duty to exercise reasonable care of the goods which are in his possession. You have obtained these goods under hire purchase terms, and therefore the law requires you to take reasonable care. Yeah, the standard of care in such cases is high. Yeah, you are taken like as a bailee. You are taken as a person who has accepted to take custody of the goods pending the performance of some purpose, as is the case with bailment. Duty of the hirer not to remove or to permit removal of the goods from the premises or even outside the jurisdiction of Kenya. And this requires that if the seller operates within the Nairobi metropolitan area, the agreement may require that the hirer will not remove the goods from Nairobi metropolitan area before paying the very last installment. The agreement may also require that he will not remove or permit the removal of the goods from the Kenyan jurisdiction, and that means maybe taking them outside Kenya to Tanzania, to Uganda, to any other country without the permission of the hirer. So what you're saying is that the hirer has a duty not to do that. The hirer also has a duty to pay the very last installment, and that duty is provided for under the law. The hire purchase price provides that. It also provided for under common law. We have seen the case of Hellbe versus Matthews, which is a very authoritative decision on which the law governing hire purchase agreements is anchored on. And therefore, what we are saying is that the hirer has a duty to pay the hire purchase price, the very last installment. That is your duty. You committed yourself to paying that hire purchase price. We want to look at the duties of the owner of the goods, and these duties, you're going to find them well stated under Section 8 of the Hire Purchase Act, which talks about the implied terms of the contract. For example, the goods are supposed to be of merchantable quality, so that the seller, who is the owner of the goods, does not sell goods of low quality and which are going to harm the hirer, who is later on going to become the buyer and also the consumer of those goods. The other duties of the seller and the owner of the goods, you're going to find them under Section 6 and 5, in which case the seller or the owner of the goods is the one who is required to alert and to inform the hirer about the hire purchase price and also the cash price, and also to draft that agreement to ensure that it is written in English and is deposited with the registrar of hire purchase agreements. So the duties of the owner of the goods are well stated under the Act. You're going to find them under Section 5, 6, and 8 of the Act. So what are the remedies of the owner in the event that the hirer does not meet his obligations under the hire purchase agreement? The owner of the goods has can terminate the agreement and repossess the goods, and that is in the event that the hirer does not pay the very last installment. He can also sue for damages. He can proceed to a court of law and claim compensation, claim for specific performance, claim for quantum merit, and such other remedies that are available in the law of contract. Where this happens, the owner may repossess the goods and invoke the minimum payment clause, so that if the hirer had not paid that minimum payment clause under section 15, then he's going to be compelled to pay half of the hire purchase agreement or any other money, any other amount that is stated under the hire purchase agreement. So these are the remedies, and I only prepared these remedies to help you just imagine what remedies the court is likely to award to an owner of the goods whose hirer has declined to pay the very last installment. So that is the end of our discussion. Remember, this discussion continues both on Microsoft Teams and also on the e-learning portal. Please take care, keep safe, and let us continue this discussion on those two platforms. My email address is also available. You can consult with me through the university email that you all have, and you can refer to it from the course outline that you all have. Thank you very much, and let us meet in our next class.
These televised lectures supplement our robust online learning going on our MKU online platform. You can view more on our televised lectures via our online platform. We are in a digital era, and Mount Kenya University knows this. The following are the steps to follow so as to complete your online application. Download the application form from the website www.mku.ac.ke. Attach copies of your academic certificates and ID. Pay the application fees via M-Pesa pay bill number 270988. Your ID is the account number. 2,000 shillings is the charge for a postgraduate. You can also deposit in the bank accounts provided on the website. Then email all the above to apply@mku.ac.ke.